Hello there. I hope you're safe and well. My name's Henry Quinlan. I'm the head of DLA Piper's Litigation, Arbitration and Investigations practice in the Middle East. During this introductory video, the first in a series which will be delivered by me or other members of DLA Piper's disputes team, I wanted to provide a general introduction to our online interactive tool, which we've called Dispute Resolution in the Middle East, which can be found at the URL which will appear during the course of this short clip. The tool is designed to act as a guide to all comers, whether they're new to the Middle East or in need of a refresher on a particular subject, on the many and various stages of dispute resolution which our clients can encounter while doing business here. The guide breaks down the dispute process into 16 easy-to-follow stages, and users can either select a stage using the drop-down menu on the website or download the tool in its entirety. With both onshore and offshore jurisdictions, which have different civil and common law systems and processes, as well as proceedings in English and Arabic, the Middle East's legal framework is unique and challenging. For parties which become involved in disputes here, whether voluntarily or otherwise, the experience can be quite overwhelming, presenting an array of available options, but also potential complications. On the one hand, there are the onshore courts, which follow civil law systems, which are similar, but by no means identical, and where proceedings are largely conducted in Arabic. On the other hand, there are the offshore courts, such as the DIFC and ADGM in the UAE and the QFC in Qatar, which follow common law systems and where proceedings are conducted in English. And between the two, there's arbitration, which is becoming the dispute resolution mechanism of choice among international parties here, where there's a wide choice of seats of arbitration, both onshore and offshore, and that choice can often prove to be very important. The final complicating factor is that it's very common for disputes in the region to involve more than one proceeding. For example, where each party commences competing court or arbitration proceedings, whether onshore or offshore, or where interim relief is sought in one jurisdiction in support of substantive proceedings in another, or to take a final example, where enforcement of a judgment or award obtained in one jurisdiction needs to be enforced in another. And because of this potential multiplicity of proceedings, it's critically important to have planned one's strategy and to have understood the potential implications of a chosen strategy before one commences proceedings. It's one purpose of this tool to assist you in gaining an initial understanding of the options which are available and what choosing a particular option might mean for you. For that reason, the tool takes you from the very first step, such as obtaining powers of attorney for onshore proceedings and understanding which courts or tribunals your dispute can be referred to, right through the various court or arbitral processes and all the way on to enforcement of an award or judgment. Presently, the tool primarily focuses on the UAE, though as one of the largest dispute practices in the region. We also have offices in Oman, Bahrain, Qatar, and a collaboration firm in Saudi Arabia, where my colleagues can answer your questions as necessary. If you need any further information or have any questions about the Middle East dispute resolution process, please feel free to email me at the address appearing below. I do hope you have time to look through the tool, and of course I welcome any feedback which you may have on how it may be improved or developed further. I or members of the team will be producing future podcasts or videos on some of the specific stages discussed within the tool, but until then, I wish you well and thank you very much for watching.